Good afternoon or morning, whenever you're watching. Welcome. All right, I am going over here because it's been a really difficult recent period of time where some medical providers, in this instance, it was largely mental health providers, which I would say it's the majority of the time when it happens, it's mental health providers. I don't know what confusion they have on the law that they have to comply with, but for the maybe 2% that drop the ball, and I'm pulling out that number, I don't really know what it is. They really do a disservice to their patient slash client. So they seem to be unaware that they are committing HIPAA violations, egregious HIPAA violations, when it comes to the access to medical records that their patient slash client has under federal law. Just this week, I saw a rebuttal from a mental health provider to a patient refusing to provide the medical records unless the patient paid a three-figure fee for them. Now, this is despite the fact that the patient's request is that the patient receive them electronically. That means no printing, no ink, no paper, no stamps, no mailing, no going to a mailbox, none of that business. In fact, it would mean either in this case by fax or by email, both of which are done without printing out the paper. So there's no physical cost. There is arguably a few minutes of cost for the labor charge of the employee, the clerk, obviously not high end guys. I don't think you need a college degree for this job to press the button and send the electronic copy to the fax number or the email that the patient has requested it be sent in their high-tech HIPAA form request. So what this particular entity has done, according to everything I've been shown by the patients, has refused to provide the records unless the patient pays this three-figure fee for the records, for a copy of the records digitally sent to them, ting, ting, press a couple buttons. So it's just ironic. So the patient has sent the citations to the federal law. This particular provider, who happens to be in Pennsylvania, has cited back saying Pennsylvania law says I can charge this because it's reasonable. Well, actually, Pennsylvania law doesn't apply because they sent you a federal high-tech HIPAA, and HIPAA preempts less favorable state rules. So they're definitely violating and apparently continuously. So that's a whole nother thing we'll get into. Should we file an Office of Civil Rights complaint? Should the patient do that? I help with those things. I have no problem doing it. They're very quick and easy. But we'll see. I don't know what the patient's going to choose to do. But let's just go over an example of a recent November 19th, so just the other day, 2024, Health and Human Services Office, that's the federal, the Office for Civil Rights imposes a $100,000 penalty against a mental health center for failure to provide timely access to patient records. Okay, so kind of thinking I should maybe put a copy of this out there so that this particular patient that sought my assistance or opinion can have it and can perhaps shoot a copy of it over to that mental health provider who is putting this patient not only at a disadvantage for her needs, whatever they are, which is nobody's business but hers. Yeah, and putting a real difficulty and potentially going to cause her to lose a legal matter, in which case, honestly, I think someone should maybe start a little litigation there, because until someone feels it in the pocket, I don't think they're going to do a hill of beans about it. It's easier for them not to produce the records. A lot of times they get to coerce a patient into sending that money. Think about that. Let's say it's $150 to get one's records. And sometimes you have to order them multiple times, like the most recent updates. Imagine if they have 100 patients that need it. They don't even have to practice mental health anymore, man. They're making enough income based on just charging for medical records that are digital. So here we go. So the Office of Civil Rights imposed a $100,000 penalty against a mental health center for failure to provide timely access to patient records. I'm just going to ad-lib it as I go along. The civil money penalty marks OCR, that's the Office of Civil Rights, because these things, if it's under HIPAA, it's under the Office of Civil Rights, guys. It doesn't have to be a discrimination case, is my point. You are not given the access you are entitled to. And you should probably know what kind of access you're entitled to before you jump on the bandwagon. This was the 51st, and that's a pathetic number, HIPAA right of access enforcement action to advance patient access to medical records. 51st. I think that is kind of pathetic. I know 51 myself of people I know. So it's pretty pathetic if that's the entire enforcement action they've taken in all this time, across the country. But anyway, it's the 51st. So, and I did see like 2 years ago that I think they were only at number 27. So maybe they are stepping up and putting a little more bite to their ability to enforce these things. Okay. So they declared on November 19th that today the U.S. Department of Health and Human Services, that's HHS, the Office of Civil Rights, announced the $100,000 civil monetary penalty against Rio Hondo Community Mental Health Center, aka Rio Hondo. It's in California. But as you can see, I'm dealing with my patient I'm assisting is dealing with a Pennsylvania Monroe County mental health provider who is egregiously violating these HIPAA rights. So let's see what kind of fun this is. The penalty resolves an investigation into Rio Honda over a failure to provide a patient with timely access to their medical records. HIPAA, privacy rules, right of access provisions, and there's a link here. I'll link this to you guys. Requires that individuals or their personal representative have timely access to their health information within 30 days with the possibility of one 30-day extension and for a reasonable cost-based fee. So the key here is they weren't provided access. Now the provider is probably saying, well, we did provide access if they pay us a reasonable cost-based fee. However, we already know from the other provisions put out there that $133 is not a reasonable cost-based fee for electronic records, aka fax or email. There is documentation to that effect. So they are, and by the way, the documentation has been provided to them, and they still come back with, we think we're right. Okay, think you're right. Go ahead. Maybe you'll get that $100,000 penalty. Okay. Yeesh. Okay. So they go on to say that OCR enforces the HIPAA privacy rule with the access rates within, with the possibility of the which establishes the national standards to protect national standards, people. You can't rely on your state to get you out of the obligation to give your patient the records at a reasonable cost-based fee. Cost-based means you can't make up the fee. So let's look at that $133 fee one particular provider tried to charge their client for an electronic copy, their patient. 133. Okay. So if it takes 5 minutes, let's say it even takes 15 minutes to press the buttons to send the electronic file to the email. Got to type in the email or the fax number. That's like 10 digits, right? Let's say we give them 15 minutes. Clearly, it's not going to take 15 minutes, right? Does it take you 15 minutes to type out 10 numbers? No. Okay. $133. Let's say that is the fee. for 15 minutes of work. Gosh, I think that means the person that they hired to copy and send records is making over $500 an hour. Am I doing that math right? Hmm. So now if a HHS tells us elsewhere that if they're going to say it's cost-based, and if they're not otherwise going to go with the expected $6.50 cost for electronic record provision for pressing those couple buttons, then at the patient's request, they have to give an itemization of how they came to that number. It's got to either be actual, that very particular sending rate on that day, or an average overall. So again, tell me how you get $133 for a couple minutes worth of, and let's even say if it went up to 15 minutes of a clerk. What clerk makes over $500 an hour to do that? My guess is none. So take home point here is amongst other things that a patient can then in writing with proof that they sent it, ask for the itemization. I would say I want the name of the clerk or the last name, whatever, and what their hourly rate wage is, what their credentials are. I mean, what credentials do you need to press a couple buttons? I don't know, but anyway, I don't think you need college. Yeah, and how many minutes it took them to do this. Now, if they say it took them 3 hours, mind you, they can't charge you for the time it took them to go find your file, to dig it up, to figure out, which dates you want that's in your HIPAA form. And this is all documented by HHS. So the parameters what are considered reasonable and unreasonable. So this is nothing new, but some of these providers refuse to look at it. I suppose because they're making a crap load of money off of medical records, perhaps because their mental health provisions are not earning them so much. Maybe they're not doing such a good job. I don't know. Okay, so if you ask for that itemization, if they refuse to give you the $6.50, I always give them up to $10, but then keep copy of the fact that you requested that, the details of that, because you want to see how they come down to, I mean, how much time was spent doing what? What are you charging for? They can't charge you page-based. That's expressly prohibited. So they're going to have to give the wage they pay the clerk, and if it's unreasonable wage, so they can get an unreasonable charge, So if you have that proof and they continue to not immediately then send the records because they're holding out for this big windfall, you could file that complaint with the OCR. You can do it right online. You can also fax it. It's so easy, guys. I've done them before for people. I put them together for them. And with the proper documentation, I believe, and you have to I believe the OCR requires that you be willing to ask additional questions if they have them. And if you don't, it might be that unless you've attached all the documents that are, relevant, they might not follow up with it. So you have to kind of be available for that. But if you have that and you have all the responses from the provider refusing to provide them to you, demanding X amount of dollars, not providing you with the itemization of how they come to that extraordinary bill, I think it increases the chance that the OCR will put a little bite into it. Are they going to do $100,000? My guess is they're not going to unless the person has a pattern with many patients who have complained. I think it's got to be big. Look at this. They've only done 51 of them in years across the entire country, but they do reach out. And I think it's when they get cooperation. And most of these medical providers will cooperate once they get the big federal OCR on their back. So it might be worth doing because the failure to do it is just adding to the fact that more providers are the ones that are unprofessional anyway, are willing to violate this rule with the hope of a quick 3-figure payday. It's ridiculous. I can't believe they're doing it. I mean, they're selling for that little bit of money, they're going to violate this. But anyway, okay. It says here with regard to this Rio Hondo in California, OCR launched an investigation after receiving a complaint from a patient that they were not given timely access to their medical records despite multiple requests in writing and by telephone. OCR's investigation found that it took nearly 7 months from the time the patient first requested the records until Rio Hondo provided them. Remember that, guys, there's a 30-day time limit. And Rio Honda could have gotten, most likely, a 30-day extension had they just been upfront and doing their job. The patient, blah, blah, blah. I just repeated that. Oh, the patient made multiple telephone calls in July and August of 2020 regarding the status of her request, but did not receive the requested records. Based on the facts, OCR found that Rio Hondo failed to take timely action in response to the patient's right of access in accordance with the HIPAA privacy rule access provisions. In July 2024, OCR issued a notice of proposed determination to impose a $100,000 civil monetary penalty. Rio Hondo waived its right to a hearing and did not contest the findings of OCR's notice of proposed determination. As a result, OCR's investigation, the patient received their records in 2020 finally. They have a link to the notice of proposed determination, and they have a link to the notice of final determination. And they have a link to OCR's guidance on the HIPAA right of access that is available. And that is for the professionals. So it's a kind of link where you could actually print it out and send it to a remiss provider. You know, it's probably a few pages long, and if they're too lazy to send you your medical records, they may be too lazy to read their legal obligations. But you can send it. And why not? And have proof that you sent it. I mean, the more proof you have of trying to help them do their job and not violate HIPAA, I can only imagine that that is in support of the fact that they continuously and willfully chose to do so anyway, despite your efforts and your help to get them on the straight and narrow. They go on to say, OCR is committed to enforcing the HIPAA rules that protect the privacy and security of people's health information. And they give a few more links. If you believe that your or another person's health information, privacy, or civil rights, such as right to access, has been violated, you can file a complaint with OCR at, and they give the link. If you need me to read it, it's https://www.hhs.gov/OCR/index.html. And note that all of those are in lowercase, no caps. Look at that. HHS OCR is on X, formerly Twitter, at capital H, capital H, capital S, capital O, capital C, capital R. Who knew? They're on the new Twitter X. Awesome. Okay. Anyway, so what do you think, guys? If I see any more of these, you know, failure to provide timely access is not excused because you're trying to wait for a fee to be paid that violates HIPAA as well, the demand for the fee. So they're not reading the stuff that's been sent to them about what is considered a reasonable fee. The reason why the fallback default of $6.50 has been laid out by HHS, I believe, is because that is what is expected to be the cost. If you're paying someone $20 an hour and it takes them, you know, 20 minutes even, you know, you might have a $6, $7 labor cost because it's the labor cost. There is no physical things that they can charge for when it's electronic. So when they're going to try to prove or charge something different, they have to follow the rules as to what can be included if they're not going to use the default average of $6.50 and they're going to go do their own average, what happens to be the case in their practice, or their actual cost for that particular provision. And because they can't charge for all the ridiculous things that they might otherwise think they can be, like I still see per page, I still see it all the time. Well, we're sending you 200 pages and the first 2 pages are going to be, the first 50 pages are going to be $2 a page. And then we're going to charge you 80 cents for the next 100 pages. And then I've seen it all. It's ridiculous. Okay, I go on. This is event But anyway, if you guys are having issues, I mean, honestly, no one should be paying more than $6.50. And I'll even give them a little leeway if they want to jack you for another couple bucks, just because who wants to fight the battle? If they're asking for electronically provided records, fax or email. They can't say no. Anyway, I'll talk to you later. Bye, guys.